So here's a question for you. Is it worth challenging the outcome of a bid if you have been unsuccessful? Now, for a lot of people, the attitude would be, well, we've been unsuccessful, we was robbed, that sort of thing. We can't change the buyer's mind, and they'll be a bit angry and things like that, be a bit bitter. I suppose the downside of it could put them off bidding in the future, which is a bit of a shame. However, if you have got good grounds to challenge the bid, why not? I want to talk about something very, very recent. The date of recording is the 12th of May 2026. What I'm going to talk about is very current, some articles that were released beginning of May. And this relates to some case law under the Procurement Act 2023. So this is also really exciting in terms of new legislation, or still relatively new legislation, and actually things happening where case law start going to underpin certain things of the law. Now, in this case, the incumbent, a car park management company, they were the incumbent, the buyer was NHS University Trust. They were unsuccessful and they challenged the outcome of the bid. Now, what was actioned, that there was a suspension put in place in terms of preventing the award of the contract. Okay, so this is something that's allowed under the Procurement Act. What used to happen under the Public Contract Regulations 2015, so the old legislation, if this happened, a judge would look at it and lift the suspension and potentially award damages to the incumbent. However, in this case, the challenge was made in terms of errors in the contract notice and contract award notice. There was a challenge made about transparency, a challenge made about equal treatment or unequal treatment in this case, and also a challenge made about record keeping in terms of the assessor's notes who were evaluating the bid. What is really interesting here, I think, is that the suspension was not lifted, that it was found that actually, something did go wrong with the process of the whole procurement exercise. So that suspension is still in place. Now, it might not be the last we hear of this case, because the authority, the buyer, could appeal against it. So it could be very interesting to see what happens with it. But I think what's really interesting, what's real key points with it is, first of all, yes, it could be well worth your time challenging the outcome of the bid, but also in terms of the Procurement Act, and there starting to be case law now being applied to it, I think it makes it very, very interesting.